Most people believe their family home is untouchable after they die. They spent decades paying the mortgage, maintaining the property, and planning to leave it behind for their children. But what if I told you there's a legal process that allows the government to step in after death and claim that house before the family gets anything? And even worse, most families don't discover it exists until it's already too late. In this video, you're going to learn the 5 specific ways Medicaid can legally go after a home after someone dies, including the one method that blindsides families the most because it targets assets they believed were fully protected. Stay until the end, because the final method is the one that catches people who thought they planned everything correctly. The entire system traces back to a federal law passed in 1993 called the Medicaid Estate Recovery Program. Under that law, every state is required to seek repayment for certain Medicaid benefits paid to people over age 55. That includes nursing home care, long-term assisted living, and even in home care services paid through Medicaid. The problem is that most seniors never realize the bill doesn't disappear after death. The state waits, then comes back to collect from the estate. And for many families, the largest asset in that estate is the house. A lot of people assume that if there's a will, the home automatically passes to the children. But Medicaid claims come before heirs receive anything. If the state paid tens or hundreds of thousands of dollars for long-term care, it wants reimbursement first. In many situations, the home ends up being sold and the money goes to the state before the family ever sees a dollar. Some families lose nearly all the equity their parents spent a lifetime building. The first and most common way Medicaid takes the house is through probate estate recovery. This happens in every single state. When someone who received Medicaid benefits dies, the state files a claim against the probate estate. That means any property passing through the will becomes exposed to recovery. If the house was titled only in the deceased parent's name, it enters probate and the state's claim gets priority over the heirs. Imagine a parent who spent 3 years in a nursing home with Medicaid covering the cost. Nursing home care can easily exceed $120,000 per year. After 3 years, the total Medicaid bill could be around $360,000. Now imagine the parent's home is worth $400,000. When the parent dies, the state files its claim during probate. Before the children inherit anything, the Medicaid bill gets paid. Suddenly, almost the entire value of the home disappears, and the heirs are left splitting a fraction of what they expected. What shocks many families is how automatic the process is. The state usually doesn't need to sue anyone. It simply files its claim with the probate court, and federal law requires the court to honor it before distributing assets to beneficiaries. Families often believe the will protects them, but the Medicaid claim overrides the will completely. There are a few protections, but they are temporary. Medicaid generally cannot recover while a surviving spouse is still alive. The same protection applies if there's a child under 21 or a child who is blind or permanently disabled. But once that protected person dies, the state can return. It doesn't matter if 10 or 20 years have passed. The claim can still be enforced later against the estate. This creates situations where families think everything is safe, only to discover years later that the state was waiting in the background. A father dies after receiving Medicaid benefits, leaving the home to his wife. Since the wife is still alive, the state waits. Then years later, after the mother passes away, the family receives a letter demanding repayment not only for the father's care, but also for the mother's Medicaid expenses. By that point, the children may already believe the house belongs to them, but the Medicaid claim comes first. The second way Medicaid can take the house happens before death, while the parent is still alive. This process comes from a law commonly called TEFRA, created under the Tax Equity and Fiscal Responsibility Act of 1982. Under these rules, states can place a lien on the home of someone receiving Medicaid if they are considered permanently institutionalized in a nursing home. That word permanently changes everything. Here's how it usually unfolds. A parent enters a nursing home after a major illness or injury. Medicaid begins paying for care. The state reviews whether the person is expected to return home. If officials decide the nursing home stay is permanent, the state can place a lien directly on the property. The lien doesn't usually force an immediate sale while the person is alive, but it attaches itself to the deed. That means the property can't be sold, refinanced, or transferred without satisfying the Medicaid debt first. Meanwhile, the lien continues growing as Medicaid keeps paying monthly nursing home costs. Picture a parent who spends 4 years in a facility with care costing $10,000 per month. By the time they pass away, the lien may exceed $480,000. If the home is worth less than that amount, the entire property value gets swallowed by the claim. Some families don't even know the lien exists until they try to sell the home after death. One daughter spent years paying taxes and insurance on her father's house while he was in a nursing facility. She believed she was preserving the family property. Only after his death did she learn the state had already recorded a massive lien against the home years earlier. Everything she paid toward maintaining the property benefited a house she would never actually inherit. There are limited exceptions. In some situations, a sibling living in the home may block the lien if they lived there long enough before the nursing home placement. Certain caregiver children can also qualify for protection if they provided care that delayed institutionalization, but proving those exceptions requires extensive documentation, and many families don't realize they need to prepare that evidence ahead of time. The third method is where things become even more aggressive. Certain states use what's called expanded estate recovery. Under federal law, states are allowed to recover not only from probate assets, but also from assets that bypass probate entirely. More than 20 states use some version of expanded recovery. This is where families get blindsided because many of the strategies people are told will avoid probate do not necessarily stop Medicaid recovery. Joint ownership arrangements, transfer on death deeds, living trusts, payable on death bank accounts, and life estates can still be targeted in expanded recovery states. Take a life estate arrangement as an example. A parent transfers the future ownership of the house to the children while keeping the right to live there for life. Families often believe this guarantees the home avoids Medicaid recovery because the property transfers automatically outside probate. In some states, that works. But in expanded recovery states, the government may still calculate the value of the parent's life interest at death and pursue repayment from the children. Joint tenancy can create the same problem. A parent adds a child to the deed believing the home will pass automatically at death. In an expanded recovery state, the government may still pursue the deceased parent's ownership share. Suddenly, the child who thought they safely inherited the home is forced to either sell the property or borrow money to satisfy the claim. Living trusts also create confusion. Many families spend thousands of dollars creating revocable living trusts specifically to avoid probate. But avoiding probate and avoiding Medicaid recovery are not the same thing. In many expanded recovery states, revocable trust assets remain fully exposed to Medicaid claims. One family learned this after placing the parent's home into a living trust years earlier. They assumed the trust shielded the property. But after the father received Medicaid nursing home care, the state pursued reimbursement against the trust itself. Eventually, the surviving spouse had to sell the house to satisfy the claim and move in with relatives. That's why ordinary estate planning often fails against Medicaid recovery. In many cases, the only true protection is an irrevocable asset protection trust created more than 5 years before Medicaid is needed. The fourth way Medicaid takes the home involves something that sounds protective on paper but rarely works in practice: the hardship waiver. Federal law requires states to offer hardship waivers in cases where estate recovery would create severe financial hardship for heirs. But the reality is that these waivers are denied far more often than families expect. To qualify, heirs usually must prove that losing the property would leave them without shelter or financial stability. States often require tax returns, bank records, sworn statements, proof of residency, and evidence of financial dependence. Even then, technicalities frequently derail the request. Families get denied because paperwork was submitted too late. Others are denied because the heir technically owns another piece of property somewhere else, even if it's unlivable. Some are denied because officials determine the heir has employment and therefore isn't impoverished enough. Caregiver children face some of the harshest outcomes. Federal law includes an exception for adult children who lived with and cared for the parent long enough to delay nursing home placement, but states usually demand medical proof showing the care directly prevented institutionalization. Producing that evidence years later becomes incredibly difficult. One son cared for his mother in her home for 18 months before she eventually entered a nursing facility. After she died, he applied for a hardship waiver. The request was denied because he fell 6 months short of the required 2-year caregiving period. The home was sold, the Medicaid claim was paid, and he lost the only housing he had left. The reason waivers are so difficult is simple. States benefit financially from successful recovery efforts. Every dollar recovered helps offset Medicaid spending. In some states, outside recovery contractors even receive a percentage of the money collected. That creates a system where denying waivers can financially benefit the people enforcing recovery. Now we come to the fifth and most shocking method, the one most families never see coming. Nearly everyone has heard of the Medicaid 5-year look-back rule. People know that transferring a home shortly before applying for Medicaid can trigger a penalty period where benefits are denied, but many families don't realize the consequences can continue even after death. Here's the dangerous part. If a parent transfers the house to a child within 5 years of applying for Medicaid and then dies during the penalty period, the state may pursue the child directly for repayment. Imagine a father transfers his home to his daughter. A few years later, he suffers a stroke and enters a nursing home. Medicaid reviews the transfer and imposes a penalty period because the house was given away too recently. Before the penalty period expires, the father dies. Many families assume the issue ends there. It doesn't. The state may argue the transfer was an improper attempt to avoid Medicaid costs and seek repayment from the child who received the property. That means the daughter who thought she protected the home may suddenly face a massive claim personally tied to the nursing home costs accumulated during the penalty period. At that point, the child may have to pay the debt from personal savings or risk losing the home through a lien or legal judgment. Families who thought they were protecting assets often discover that the transfer itself created the liability. That's why simple deed transfers can become extremely dangerous without proper planning. The 5-year rule isn't just about delaying Medicaid eligibility. In some cases, it creates long-term financial exposure that survives the parent's death. So what should families do? The first step is understanding whether their state uses expanded estate recovery rules. That determines whether non-probate assets remain vulnerable. The second step is avoiding informal transfers done without legal guidance. Adding children to deeds or relying on basic trusts can backfire badly. If parents are still healthy, families should speak with an experienced elder law attorney about Medicaid asset protection planning early, before care is needed. Timing matters because most effective protections require planning more than 5 years in advance. If a loved one is already in a nursing home, families should closely monitor how the stay is classified. A determination that the parent intends to return home may prevent certain liens from being filed. And if a claim has already been filed after death, families should never assume the amount is final or automatically valid. Some claims can be challenged, negotiated, or reduced with proper legal help. The biggest mistake families make is waiting until after the crisis begins. By the time the nursing home bills start piling up, many of the strongest legal protections are already off the table. Medicaid recovery laws are deeply embedded in the system, and once the state begins the process, reversing it becomes incredibly difficult.